My name is Hans Micklitz. I'm professor for economic law here at the European University Institute. We organized this workshop jointly together, the Law Department and my ERC project with the Florence School of Regulation. In the energy sector, you don't have much litigation before the courts. The reason is that all the parties concerned prefer to solve problems outside courts, mainly in so-called out-of-court settlement mechanisms. And this is true for the business sector, and it's also true for litigation or types of conflict between the business and the private customers. The purpose of the workshop was to bring people together who are working in that field, regulators, practicing lawyers, consumer organizations, and to discuss with them in the two areas, means business-to-business conflicts and business-to-consumer conflicts, how these are solved. That was the first workshop ever organized in the area, and to fill the black box, if I may say so, because there is no knowledge available publicly that can easily be accessible to those who are interested and working in the field. So you have to speak to people and you have to rely on their experience in order to understand what's on. The major outcome and the major finding of the overall workshop is twofold. I think we all learned that in business to business in the last years, there is a steady increase of litigation which is solved via arbitration, whereas in the business to customer, private consumer area, we have mainly ombudsmen, or we have conciliation commissions, settlement commissions, depending on the country where these private consumer problems are solved.
I'm Giuseppe Bellantuono, second national expert at DG Energy of the European Commission, Energy Policy Coordination Unit. I'm presenting some ideas about ADR in the energy sector in this conference. Just as a personal view, my opinions, of course, are not binding on the Commission. And there are two key ideas that I want to present in this conference. That is, first idea is ADR in the energy sector, ADR procedures are very much connected to the broader goals of the energy union strategy. That is, providing effective enforcement mechanism for consumer rights is very important for the accomplishment of the goals of the energy union strategy. And the second key idea is that we are in an energy transition. Energy markets are in transition. The new business models, new technologies are emerging, new energy services. And this means that energy markets are becoming more and more complex. And this is another reason why it is very important to provide energy consumers in Europe very effective ADR procedure, that is, mechanisms that help the consumers to settle their disputes and also to trust the markets and to increase their participation in the markets.
Hello, I'm Martin Salamon. I represent the European consumers through BUIC in Brussels. I'm here to talk about consumers and alternative dispute resolution. How do consumers get their rights when they have a dispute with a company? This is not another way of making consumers satisfied. It's actually getting their rights. And we see that ADR systems have to be independent, they have to be well-funded, consumers have to know about them, and companies have to be forced to follow the decisions of these ADR bodies. What we learned today is there are great differences between how it's done in European countries. That can be good, but it also means that in many places consumers are not getting their rights. I hope that this conference will help solve that problem.
Hello, my name is Ernst Tremmel. I'm working at the Agency for the Cooperation of Energy Regulators. Today I talked about ADR in member states and at ACER. Regarding ADRs in member states, the focus was on results from national regulatory reports on which ADRs have been implemented in their member states and how they work. Those results suggest that the ADRs mechanisms function quite differently in the member states. Coming to ACER, the discussion was on which role ACER can play for dispute settlement, and that is mainly in the context of solving disagreements between national regulatory authorities on cross-border issues.
My name is Leigh Hancher. I am from the Florence School of Regulation, where I'm responsible for EU energy law and policy. Today I've been talking about third-party access under the third package rules of the European Union. I've been looking at issues to do with dispute settlement in national cases and comparing the evolution of the regulation of national disputes with what might happen in the foreseeable future as we move towards procedures and rules to deal with cross-border infrastructure and cross-border issues, cross-border regulation and cross-border disputes which will inevitably arise. My interest is primarily in the legal concepts that we find in the new directives, especially the Trans-European Network Directive and the rules on cost allocation for cross-border infrastructures, where we find a lot of issues in the regulation which are perhaps not as clear as one might hope. Some of the definitions are very vague. The terms for cooperation between the regulators in deciding how costs are to be allocated that arise from these new infrastructures into their national tariff systems raise many interesting legal issues, which I explored today during my presentation. In particular, how a third party, such as a user, system user, might want to challenge some of these decisions, which are in fact multi-layered because they will involve several different regulators with different national rules, which somehow have to be coordinated. And on top of that, we have a European organisation, the ACER, who can also be involved in this decision-making process, can take binding decisions. So for a third party, this is a novel situation. If they wish to contest the outcome of this procedure, where do they start? How do they start a procedure? Who do they go to? And which legal system? So these are all very novel issues that we have to, I think, quickly start to address. So that has been the focus of my presentation today. Thank you.
Hello, I'm Cornelis. I'm the Secretary General of NEON, the National Energy Ombudsman Network. I'm here to represent the network of ombudsman, independent energy ombudsman. As you will see, there are many ombudsmen present in the room, and most of them are already members of NEON. But NEON is the umbrella organization for those independent energy ombudsmen. So I would say that I'm bringing my expertise and my knowledge of the the way European Union works, in the sense that without this European network, those individual members would be fairly less strong and powerful.
My name is Karl Pornbacher. I'm a partner at Hogan Lovells, which is an international law firm. I'm based in Munich. I was talking today about dispute resolution in gas-to-gas disputes under long-term supply agreements, which are solved by arbitration. I was trying to show that while arbitration is probably the only means to solve these sort of disputes, there are limits to the efficiency of these dispute resolution mechanisms due to the complexity, to the technicity, and to the variety of questions, of technical and commercial questions of these dispute resolution mechanisms.